Good morning to you all. My name is Einari Karhu. I'm a tax partner at Taxand Finland. So our panel session will be about the tax audits, especially in transfer pricing, and it is kind of a common feature in international taxation of the past years. It's a rapid increase in transfer pricing audits, and I guess the biggest thanks goes to OECD. All the work they are doing there will eventually lead to new ideas of the tax authorities and especially in audits. Although cases are always different, and all tax audits or transfer pricing audits are one of a kind. We have our panel aims to identify certain aspects which are common and topical in transfer pricing audits. But first, let's introduce our panel. Please.
Ladies first.
Okay, my name is Renata Blahova. I'm partner at BNB Leitner in Slovakia, which became a member of Taxand just this year. And I'm specializing in transfer pricing. It's really a heavy focus of my work. And I can only confirm what Einari said. In Slovakia, which is a capital importing country, contrary to my colleague who is from Germany, the income tax audits in my country are focusing 90% on transfer pricing. You hardly see anything else the last 5 years or so.
Yeah, thanks a lot. My name is Michael Pulz. I'm a partner with Flickhocke Schaumburg. That's Taxand Germany. And of course, the issue of transfer pricing audits, it's also very severe in Germany. We're doing a lot of defense work for our clients. So transfer pricing, due to the fact that Germany is a very export-orientated nation, it's the 4th biggest economy worldwide. We have a lot of transfer pricing issues. So thanks to the OECD, thanks to tax authorities for giving us that work.
Good. Our panel will mainly focus on cases and case studies in relation to transfer pricing audits. But before we go into those, we thought that it might be interesting to discuss a little bit about why we are where we are in terms of increase in transfer pricing disputes, and what are kind of the main issues that are disputed at the moment. And one common feature of transfer pricing audit seems to be basically the administration's fear for the base erosion. It guides, at least from my perspective, it guides a lot the audits and also the findings of the tax authorities. Another relevant issue is the backlog of new tax regulation, which has affected the rise in disputes as well. It seems that the new tax regulation is catching up with the structures that companies or taxpayers have been using, and as well as the business models, and which leads to the audits leading to disputes. Then one important fact is that the tax administration's tools have developed. We have, when in the past the lack of information has basically helped taxpayers in a way that the tax authorities have had much less of available information. With all the increase in information exchange, we are basically in a position that all structures used and all the pricing used has to be transparent. I mean, this is something that companies should be aware that there's no way to basically hide. Then one issue that we could maybe emphasize, or one issue that could be one of the reasons is the fact that in many countries there are not that many ways to settle a transfer pricing audit or a dispute. For a taxpayer, it would be preferable in most cases to find a compromise with the authorities. There are countries where that is possible, but in many countries you just cannot agree. And finally, as in transfer pricing, the numbers on the table tend to increase or tend to be quite high. One reason for increase in disputes is or can be the fact that sanctions, penalty interests, and these are higher than what they used to be previously, because the amounts we are playing with are much higher.
And I would also say, Nari, it's absolutely true what you are saying. The level of aggressiveness, I would say, that we experience in tax audits over the last 5 years has definitely increased, I would say. So there is a certain feeling that is also with the German tax authorities that they're entitled to a certain piece of the entire tax cake. And this is also the reason why we have so many emotional debates in tax audits, to be honest, where tax auditors are stepping in and say, look, this is not fair what you're doing. We are not really interested in the function risk profile of the companies. This is such a huge impact on the value chain that you're doing from a total perspective, so that should result in a certain piece of cake that we're entitled to. And that makes debates much more difficult in my experience.
Okay, then what usually is well, are audited, or what usually is disputed. I would say the largest cases, of course, they relate to business restructurings, centralized business models, or if a company has a decentralized business model, that is something that we find very sensitive in audits, and especially for tax authorities to accept. IP transfers, IP licensing, as well as financial transactions are the ones that are the most in play, or the most interesting for the tax auditors. BEPS is an issue which comes across very often. At least in my country, it is also something that tax authorities consider that should be applied from day one. I mean, we are fighting cases which are based on BEPS reports that, but tax authorities want to apply those for 2006. It has been very difficult for a taxpayer to find or understand in 2006 that they should have understood that in 2018 OECD thinks in a fully different way.
I think it's Finland, not the only country experiencing, and to a certain extent I have understanding for that. Just to illustrate, Marlon's colleague Thomas Balko was an important guy at the Ministry of Finance, and is representing in Slovakia, and is represented quite many disputes in Slovakia. And of course, you cannot prevent if the person is representing a case, even though it's minus 10 years, he's simply applying the same argumentation, even though it's not officially in place yet. So that's as easy as that.
Sorry to jump in, but it's true. And we actually just had that discussion within the Chapter 4 review. From public commentators, I think EY raised a question on shouldn't the Chapter 4 make explicit reference to whether the transfer pricing guidelines can be applied retrospectively or not. Very unfortunately, WP6 didn't want it to put that explicitly within the transfer pricing guidelines, because it's something that will be done or dealt by the domestic rules. But it's true, because some commentators said, you know, the changes that have now been produced in the 2017 transfer price guidelines is not just minor changes. It's not only, you know, another example here and there. You have the whole risk analysis to begin with. So how are you going to produce or reproduce a transfer pricing work backdated like 5 years, considering, oh, maybe in 5 years I will have to come up with who controls the risk, if it's a shared assumption of risk, or it's true that it's complicated, but unfortunately it didn't well the way we thought it would, and so we will be silent on that, and it will be up to the domestic rules to, if they want, to make sure. I think a few countries have already done that. They are very clear on which guidelines should be applied within a tax audit.
All right. So we have chosen 5 cases which exemplify kind of the wide range of issues that usually are subject to transfer pricing audits. And we have cases relating to kind of technical transfer pricing application, some more procedural questions, as well as, I would say, questions of principle recharacterization, and how far does that go in transfer pricing audits, or how far can the tax auditors go claiming transfer pricing adjustments. Let's start with a case from Slovakia concerning the selection and application of a TP method. And Renata, please.
So as you see, a simplified structure of a globally represented group, which is engaged mainly in production and sale of furniture. Used to have, the Slovak company used to have the parent with tax residency in Switzerland, and then they moved a few years ago to here, to Netherlands. Just for the background, why you don't see the country of parent company. It's a rather decentralized system, how the company is managed, just to follow up on Einari. And you can understand that for business purposes, it may be a very successful model, because they enforce quite competitive procedures even within the group. There are, in this case, a few lines, which you could call for transfer pricing purposes transactions. Starting with production and ending with retail. I will not go on details, but for Slovakia, the case we were representing the last 3 years, there was a producing company, production company. This is the chair company named, and there were 2 basic transactions within the company itself, within the producer. One at the very early stage of the value chain was producing board panels, which we considered when reviewing a typical commodity product, even having its own indexes, which pricing is quite clear. There is market price for that, quite easily assessed. And then the other line, furniture itself, which was more difficult to argue that you have unrelated party producing and selling the same. So these 2 lines, approximate ratio 30 to 70%. What happened if you can switch. Since this is a very competitive business, not only within the group, the global group, but also elsewhere, company, at least in Slovakia, but also in other countries, didn't really generate a lot of profit margin, and applied, even though characterized as a contract manufacturer, applied a COP method. This, when tax authority in Slovakia reviewed the company, we have tax audits which are not for a long period of time. What our tax authority in Slovakia does, they do a sample, so they pick up a year, review, and try to look on that sample year what are the issues. Here what they've seen, and that was a 2011 case, I think, they were simply not happy with the COP method and applied the TNM method. So that was like the major issue there. Moreover, they produced, since the company didn't have any benchmarking documentation available, they produced their own benchmark based on Amadeus and came up with quite a high median profit margin of almost 7% and made a tax assessment for that particular year. But of course, the risk was, as statute of limitation in Slovakia is quite long, it's the 10-year period, it was clear to the company that it's exposed. So we tried to help them. Well, there were of course issues with benchmarking, and I will come maybe later on back to that, so you can switch to the next slide. But we really try to argue that at least for the board panels, the COP method should be applicable, because in theory that's the right and preferred method. And if you have a commodity which is quoted on the market, then if that one is not accepted, what is the COP in practice? So we really tried, but the tax authority didn't want to agree on that. So there was a choice for the company, either to go into a bilateral procedure to resolve the dispute, or to rely on a local court. We advised strongly to go for bilateral procedure, because my experience, at least in Slovakia, is it's faster than the domestic courts. And especially if you agree, then you have legal certainty, whereas with the local court dispute, yeah, it's not really the definite solution. The client decided to go for both, so it's an interesting case. And yeah, the bilateral procedure, as it is applied currently in Slovakia, requires to start with unilateral procedure. So you go to the local authority, make a request for an advanced pricing agreement, you know, the old standard of OECD. So this is what we did, and within this procedure we try to argue COP method. Yeah, the problem is if you want to go for COP method and the tax audit team is experienced enough, and they know that most global companies, even though decentralized, tend to have procedures in place where the headquarters decide, not the local company, and therefore are motivated to argue in a direction that it's from the organizational point of view not comparable to the unrelated parties producing or selling the same commodity. And in order to document their own approach, why they think it's not comparable to use the commodity pricing, they simply performed in-depth interviews within the company. And even though we tried to prepare the people, to be honest, how it will be gone, it's psychologically almost impossible, because they are exposed to pressure, and sometimes they are afraid to simply say we are independent, because then it could be for them difficult within the organization to to publish their statement somewhere. So it's very difficult, but this is what even the Slovak Tax Authority does. They do simply in-depth reviews, pick up bits and pieces of the quotes which suit them, and this is how they close the case, that the CUP method, neither for the furniture part of the business, not for the board commodity part business, is applicable. Okay. So function and risk profile low, and that's why CUP method not applicable. And yes, we want a profit margin. We were ready, of course, for this conclusion. It was not like a shocking one, but we hoped that the commodity part would go through. It didn't. So we started the second issue in the whole dispute was benchmarking. And that was, I think, the more funny part, because the tax authority used their own, relying on Amadeus, which we know from other cases is not always coming up with the best results or with the best quality, which was also, fortunately, the case here. There were not enough comparable companies, which was due to the NAC code selected. It was too broad. And therefore, many companies, even though there were a few left, not comparable. So what we did, we did our own studies, basically two, but the main was the local benchmark, so it's not Amadeus, and we find, based on the local benchmark analysis, that the tax authority has omitted, even from Slovakia, many comparable entities with much lower margins. So it was a good case because we could prove with the local benchmark, simply it's not representative, the results of the tax authority. You have seen the median profit margin. We arrived at 2% with the first benchmarks and tried to argue. Yeah, this is, you can see the interquartile range. With our benchmarking 0.8% to 5%. Compared to the tax authorities, 3.5 to 13.5. So it's really huge. This is definitely not a science, the benchmarking exercises. But we had about 30 comparable companies with the tax authorities approach, resulting into 9 comparable entities. So it was quite clear that our arguments are good. Okay, so what were the other issues discussed? Local versus global coverage. We were really curious what the tax authority will say in regarding to taking a pure local benchmark only with a much lower geographical coverage. It was basically no problem at all. So this was quite surprising. They even stated that they prefer narrower geographical regions. So that was basically a good, I think on that point we agreed quite easily. We also agreed that Amadeus doesn't come up with good quality data always. This was also another point we agreed on. We had a discussion on the quality of Amadeus also yesterday, Mark, yeah. Yeah. This NAC code was a discussion, but since it led, in case of the tax authority selection, to a sample which was not representative, was not that hard to persuade. Yeah, and the result, they refused our APA request, so it didn't help in the sense the CUP method was not approved. But since we opened this field for discussion on the benchmarking, we closed, I think, 2 weeks ago. We have a written protocol which simply states that this 2-point-something% median would be fine, and yeah. I think it's a much more efficient result for the client. The court is still in some very early stage, probably closes in the next 2 or 3 years. But it will probably help even the court proceedings. So this was this bilateral procedure initiation, even though it will not end in a higher stage, helped a transparent discussion with the tax authority. So this is what I wanted to say. And then these takeaways for you maybe. So some conclusions. Yeah, self-explanatory probably for this specific case. yeah, the local court dispute would not be that efficient. It was much more efficient to start with the APA procedure. Yeah, and we had one question due to the change of the tax residency of the holding company. What would be the arbitration convention applicability? And in theory, Switzerland in the year concerned wouldn't be part of the arbitration convention because it's not an EU party, but it was interesting that at least the Slovak Ministry of Finance in their experience confirmed that the Swiss would anyway go somehow by the rules informally. So that was also interesting. Yeah, the BEPS, if applied, yes, it was, as I mentioned, and this was not a case represented by your colleague, Marlen. It was a totally independent tax audit team. They used this BEPS argumentation a lot, defending this value chain creation, even though it's 2011 case, of course, in their own favor, not in favor of the taxpayer. Yeah, and what is for sure the most important takeaway, I think, if a small country like Slovakia is concentrating within the tax audit on a real assessment of function and risk profile, I think in most of your countries, sooner or later, you can expect that this is what the tax auditors will do. They will not rely on the documented function and risk profile. They will simply go in and talk to the personnel in the company. But please ask if there are any questions already now.
Basically, my question is, because I understand that you don't want to go to court, but there's very little jurisprudence on transfer pricing. So was that also a part of your consideration? Because from a Dutch perspective, we're noticing that taxpayers are more willing to go to court, especially with respect to the selection of TP methods, because there's a wide margin of appreciation in selecting a TP method, of course.
I think the decision of the company was rather to show that they are not afraid of hiding anything, and that they think that they have done legally not anything which could be considered as tax avoidance. I think this was like main motivation behind that. And yes, we have not recommended it because in Slovakia especially, even if I compare to the neighbor country, I'm very familiar with both systems in the Czech Republic and Slovakia, we really didn't split the administrative court system from the regular court system. That means on the district, on the low level, the judges for most of them, it's the first time they decide on a tax case at all. And not that transfer pricing, they normally don't know what it is. So it's of course, these results, they're irrelevant. You have to wait to the highest court. It's normally more probable that the Senate on the highest court has dealt with tax dispute before. But we don't have, except for one marginal case, we don't have any transfer pricing court decisions at all. There are some in the Czech Republic, which we quote sometimes when defending the clients in the tax disputes, and depends on the judges in Slovakia. They sometimes accept something like Germany and Austria. I think Austrians also tend to quote the German cases. So for our region, we in the Slovak cases try to quote the Czech jurisprudence. But yes, it's basically non-existent. So it's a short answer: no transfer pricing jurisprudence.
So Renata, basically speaking, we have the same issue in Germany. There's only very little experience given to German fiscal courts, at least at the first instance. If you go to the federal tax court in Munich, I mean, they're more experienced. They have experts sitting in the first Senate that deals with the international tax cases. But if you go to a simple fiscal court, the experience in terms of transfer pricing is very, very limited. Sometimes it's more or less like a lucky punch. It's like boxing, if you win or lose. So the risk for the client to fail with a case, it's not really low, to be honest. And this is also the reason why a lot of clients go more for a mutual agreement procedure than going to the fiscal court. They're really afraid that due to lacking experience in terms of transfer pricing, the result is not really foreseeable. It's somehow tragic in my view, but that's reality.
Okay, thank you. I propose that we jump into the second case, and Michael can continue on that one.
Yes.
This one relates to high value adding services.
Yeah, perfect. Thank you, Nari. So good key work, Renata, function risk profile that you already know. It's all right. So I brought a typical inbound case here with me that we nowadays see quite frequently in tax audits. It's actually a quite simple setup. In this case, we have a Dutch chemical company. That's the parent company sitting in the Netherlands, close to Amsterdam, for example. And this parent company has a German subsidiary, which is located in my federal state in North Rhine-Westphalia. And there was some kind of business reorganization in the former years. So the function risk profile of that German chemical GmbH was melted down from a fully fledged R&D performing company to a more or less simple contracting R&D company that is exercising some R&D contracting services. And also as a second step of the reorganization, the distribution functions have entirely been shifted from Germany to the Dutch parent company. It's a kind of central entrepreneur concept that is now applied at the level of the Dutch parent company. And there was a transfer of the underlying customer base from Germany to that chemical BV in the Netherlands. And now we're coming to the tax audit and leave the aspect of business restructuring aside for a moment. What happens now, if we move on to the next slide, that's again the explanation of the underlying case, what I just said to you. The German tax auditors are now stepping in and say, look, we have the impression that due to the fact that the German GmbH was an autonomous R&D performing company with a very deep function and risk profile in former times and is now being stripped more or less to a contract R&D taker, there is something specific, there is something suspicious about the transfer pricing setup. And due to the fact that R&D activities always have a very huge significance for the entire value chain of a company, we are of the opinion that the German GmbH is still providing high value adding services. We just had the example, Martin, in terms of low value adding services, but we also have the opposite, the issue of high value adding services. And the German auditor said we don't agree that a simple cost plus approach in terms of choosing the transfer pricing methodology is the right thing here in this case. And a simple cost plus, take a markup of 5%, that's not really sufficient given the overall importance of R&D in your overall company, in the entire group. And there are, basically speaking, three aspects that I would like to discuss with you because in my view, that's a typical inbound case that we nowadays see quite frequently in tax audits. The German auditors are jumping directly on the function profile. They're going for the significant people function. The German R&D engineers are still sitting in Germany. They are doing their work. And there's a quite simple line of argumentation that we see quite often, saying that due to the fact that there is such a strong impact on the entire value chain given or that is arising from the R&D activities, this is not a suitable thing for a cost-plus approach. And this entire debate, in my view, has been supported by the DAMPI concept by the OECD, the entitlement to profits, And if you go to the first letters of DAMPI, development, enhancement of intangible assets, this is a classical case, in my view, where German tax authorities are coming from a more global view and say, look, in terms of the entire BEPS debate, we have to ensure that, this is exactly what we said a few minutes ago, we have to really ensure and safeguard that Germany gets an appropriate share of the entire tax cake. And we cannot guarantee this by going for a simple cost-plus approach. In my view, this line of argumentation, it's fully understandable from a tax authority point of view, I would say, but there is one mistake that German authorities are doing, and that is just focusing on functions and on the overall value chain impact perspective. So we have a second thing that we need to reflect, that is the risk profile. And if you go to the chemical or pharmaceutical industry, sometimes a lot of R&D activities simply fail. Huge investments are made in terms of R&D activities. And who is carrying the potential risk of losing projects, of not being really successful? And if you leave that risk analysis aside, in my view, even the entire contractual setup, it's simply superfluous, and you can really save the time arguing with tax authorities because they're just sticking to the functional perspective. And if I understand the OECD guidelines correctly, Marlin, I think even high-value adding services, if you go to Chapter 7 of the revised guidelines, even high-value adding services can be remunerated on the cost-plus basis, in my view. I don't know what is...
Text now, yes.
So my fear is a bit that if you go back to the basic principles of the BEPS project, there are a lot of commentators that say BEPS, that's the unofficial abbreviation of basically everything profit split. And this is, in my view, not a very good development, to be honest, even in this case. So what is our takeaway? What is the core message that I want to bring to you in presenting this case is, I mean, we have to really have a decent look on the entire function and risk profile, I would say. The risk profile, in my view, is becoming much more important in future. And just sticking to the function exercise, to the overall value chain contribution, this is, in my view, much too less in order to judge a case profoundly from a transfer pricing perspective. I don't know, Willem, what is your experience from a Dutch perspective?
Risk is, of course, risk is, of course, a very important element. It's not only the functional analysis, but in assessing the risk, you also need to take into account who controls the risk. So that's really important. And especially with the DEMPI functions in the Netherlands, we take a very economical approach. So we really look at where the DEMPI functions are in order for instance, for IP to have IP here in the Netherlands. But other countries take a more formalistic approach, of course. So that also leads to a lot of discussions internationally.
I think in case of Germany, my practical experience is Germany is the biggest investor in Slovakia. We have quite many cases. And my biggest one, the same German tax authority, the Bundeszentralamt für Steuer, this is the same probably in your case, argues the other way around. If they have a company where the other tax authority like Slovakia wants a higher profit margin, then they really emphasize not DEMPE but capital risk exposure, and you end up anyway with the same office with opposite argumentation. Is my experience.
It's a bit cherry picking, indeed. Sad but true.
Have you experienced or have you seen claims where tax authorities say that this is a sale of business, this is a sale of transfer of business from I mean, how we experience in Finland is that they would prefer to have a huge lump sum tax adjustment as a transfer of business from one country to the other.
Exactly. So that is the second aspect of my case, the transfer of the customer base. What we see also in practice is that where tax auditors missed to examine business restructurings, they try to equalize their failure maybe in former tax audits by jumping into the transfer pricing methodology itself. So that is seen quite frequently, I would say. And this is, of course, the second aspect in my case. I mean, the transfer of the customer base, that has something to do with the sales function. That is completely to be separated from the R&D activity. So that has nothing to do with R&D. So, but what we see is a kind of global approach that tax auditors come along and say, look, we have the overall feeling that there is something wrong with the entire system. It's not really balanced, and if we go on the one hand for the R&D contracting services, but also the sales function. So there's a huge mixture of different aspects, and this makes debates with tax authorities sometimes really dangerous, because you have to really go for a good structure and for a precise structure of your line of argumentation. So just mixing up things and putting all things together in order to create some certain, how shall I say, discussion potential and to put some pressure on the taxpayer, this is a very dangerous thing. And from my point of view, from a pragmatic point of view, I would say that a taxpayer is very well advised to already consider these kind of difference issues in its transfer pricing documentation. So that is the first line of defense. So even in a climate where tax authorities are much more aggressive in terms of their need for income adjustments, I think going for a very solid line of defense, that means having a very proper documentation in place, that's becoming much more important, at least in my view, I would say. So this was just to give you some flavor of what is currently discussed. So typical inbound situation, I would say, which we see quite frequently. And interesting to see how these cases will be handled in mutual agreement procedures. Going back to your speech, Renata, I have also great doubts that German clients are willing to take these cases to court because they know that no experienced judges are sitting there and that really have a full scope, a full view on how the transfer pricing things are really functioning. So I'm quite curious to see how these cases will end up in that procedures.
I think Germany is still the leader, if I remember right, from the last
statistic. Yes, we are the world championship in terms of unsettled
as far as number of MAP cases which are open.
Okay, thanks. Any questions from the audience at this point?
Clemens.
Well, I was just wondering your strategy towards the transfer pricing disputes. I always take the position that a domestic litigation procedure only makes sense in rare cases. But on the other hand, as you were mentioning, I guess Germany has more than 1,200 MAP cases still open. The average duration is above 40 months on that. So what would you expect from the EU dispute resolution directive? And on the other hand, what's a little bit disappointing was the MLI project on the Chapter 4 with the mandatory arbitration, which was only, will only be applicable in very few countries. I guess in Germany it's only with 6 countries, among them New Zealand and Mauritius, which is not really probably the day-to-day case. So what is your suggestion on how to solve those issues?
Very, very good question. I think the German strategy is to go more for joint tax audits. So that is what also the Federal Ministry of Finance is currently promoting, to have that kind of joint approach, not just having simultaneous tax audit, but really have a kind of coordinated approach how to tackle multinational enterprises. And there has been a special department recently founded at the Federal Tax Office at the Bundeszentralamt für Steuern, sitting in Bonn, which especially deals with these kind of joint tax audit questions. And in an ideal transfer pricing world, the goal is to have these joint audit procedures in place within all European countries and to go for subsequent APAs, to say, look, once there is a solution that has been found, that has been settled among tax authorities, let's go for a bilateral APA and let's prolongate, so to say, the solution that we have found via a bilateral APA. And I had a very long discussion last week with the representatives sitting in that department at the Federal Tax Office in Bonn. And they told me that a lot of European countries are a bit reluctant in terms of the joint audit idea. There are some cases now pending which actually work quite well. This is what I heard, and from my own experience I can tell that the case, especially in the Netherlands, went actually quite well. But there's a lot of, how how shall I say, insecurity at the level of other European tax authorities, how to really deal with these kind of cases. But if you ask me personally, I guess that is a question of time. I guess the idea is quite good. It's a very pragmatic approach to settle double tax conflicts in terms of transfer pricing. So if you ask me personally, I would say the joint audit idea is very suitable in my view. Yeah. Willem, yeah.
Perhaps I'm getting a little bit ahead of my own presentation, but we had an expert meeting of the multilateral joint audit here in the Netherlands, which the Netherlands is heading. It's one of the OECD projects. And actually, it was also business which was very interested and supportive of multilateral joint audits. So that's also really interesting to see. And I know in Germany you have a very nice flyer on the multilateral joint audit. Your colleague gave it to me, so it's really a good development.
Yeah. Stefan Schmitz prepared it. Yeah. So there was one question.
Can you please comment on your experience with regards to bilateral APAs in Germany, especially at the speed at which it moves? And the reason why I'm asking is we are currently we are trying to get a bilateral APA between Germany and the US, and it involves outbound transfer of IP as one of the covered transactions. And the APA was supposed to cover the years between 2012 and 2016, and we are in 2018 now, and it's still an open item. So I was wondering if have you seen similar cases in Germany as far as bilateral APAs are concerned?
Very good question. From my experience, I would say that the problem is that the more complex a case is, and usually when we have IP issues that are the core theme of a APA case, German authorities are totally overloaded. And there are two departments, one dealing with the MAP procedures and one with the APAs. But due to lacking personal resources, the complex cases are lasting quite long. And even if APA cases are well prepared from a company side or from the advisor side, you still have these long periods where tax authorities keep on discussing, and there's no real progress visible. And at least going back to my client base, I actually made the same experience. In terms of more simple cases where you have simple distribution functions, it's actually quite quick, I would say. But in terms of really complex transfer pricing cases, which usually involve intellectual property, the period in which such APA procedure is settled, that's actually too long in my view.
And it almost seems like the audit team has a heavy hand in
yes.
saying, as opposed to the competent authorities having the final.
Yes, that's due to the federal system that we have in Germany, and there is a kind of internal authority cooperation between the federal tax office and the local tax authorities, and they push that case back to the local authorities, which are also responsible for the tax audit. And sometimes the coordination between the local and the federal authorities is also quite slow, and this even complicates things due to internal advisory problems, administration problems. So actually not a good news for taxpayers, but this is things how working now. And I guess that is also the reason why the federal ministry is that much pushing the idea of joint audits, to have a very pragmatic solution, to really enter into an early stage where the case is already in the stage of a tax audit, to have that debate with the other tax authority and to find a solution already at that stage in time here.
Maybe just a follow-up experience on my side with the German Ministry of Finance on a bilateral procedure initiated 2004 for our client. It's 2018. We just came to the arbitration phase. It's the committee created. And it sounds tragical, but it's not. It's the opposite is the case because it's not even a complex case. It's a simple case, but fiscally very sensitive. It's one of the biggest German companies with the biggest Slovak subsidiary, with the biggest Slovak company. So it's a precedence for all other cases. But it's the best legal certainty that the client can get, because we we know that the two countries now must agree. And fortunately, the regulations in Slovakia are structured in such a way that once they agree and it's clear it was on the state authority side, there are no penalties. So the client is out of the dispute, at least practically. And the client is happy. They are not complaining.
Congratulations, Renata. Congratulations, yeah. I mean, we also have these prominent cases, yeah, where there's a certain political pressure behind. But we also have a lot of cases which are not, where not a spot is put on. And these cases are sometimes very, very nasty, to be honest, yeah. So I guess the mistake that German authorities made is to have too less personal resources in terms of dealing with these cases. And the ramp-up phase to increase personal resources was much too late. And even the level of education is sometimes quite low. I mean, I recently had a pre-filing meeting with the APA team at the federal tax authorities, and all members of the APA team came from the input VAT department, which is also sitting with the federal tax authorities. So there was at least no real technical knowledge behind in terms of transfer pricing, which was actually very disappointing in my view, but this is also reality.
Okay, then let's jump to the next one. Another aspect
of dispute settlement. So let's just have a very brief treatment of this case because we're running out of time. So that is a typical outbound case from a German perspective, where we have a German parent company that does business in China or India, and especially with India, there is no Article 9, Paragraph 2 in the double tax treaty. So that means there is no corresponding adjustment. Yeah. And in practice, we have a lot of clients because India is a very huge and important market for the German industry. We have a lot of cases where Indian companies are doing quite well. They have a very good operating margin, a lot of money, because there is not much competition on the Indian market. Same happens in China. We have a new double tax treaty with China, but that contains Article 9, Paragraph 2. But we also have some kind of different margin situation, especially on the Chinese market, where Chinese subsidiaries of German parent companies are doing quite well. And just to abbreviate this case, what do we do in a kind of double tax conflict? Yeah, what shall we do in terms of these specific situations? And due to the fact that these two countries are that much important from a German view, and the risk of entering into double tax conflicts is that much high, what is a really good solution in these cases? So even under the German-Chinese double tax treaty, there is no mandatory arbitration in Article 25. It's tax authorities can sit together, have a chat, and go away, and there is no resolution of that double tax conflict. So this is a very nasty thing for our German clients. And a lot of clients really think about going to fiscal courts in these cases, which is also not really easy exercise, I would say. And the other strategy that we recently discussed with German authorities is to go for a tax waiver, to say, look, due to this kind of overall circumstances, German companies, given the importance of these foreign markets for the German industry, we have to really protect them from double taxation. And what could be a solution is to go for a tax waiver, to go for a divergent tax assessment, and to lower unilaterally the German tax burden, so to say. There are some discussions going on in the federal ministry in Berlin that wants to provide guidance for these kind of special cases. Another case could be Brazil, where we even don't have a double tax treaty. How do we deal with these cases in practice? And I don't know what's the OECD position on it. I think some voices in the German federal ministry said in order to mitigate the overall risk that we are running into double tax conflicts, especially with these countries, should be that CBCR-related information should only share it amongst those countries which are willing to go for mandatory arbitration in a mutual agreement procedure. So that could be one kind of solution how to mitigate the abstract risk of entering into double tax conflicts. But I don't know, is there any OECD position on this?
Yeah, no, I'm not an expert on CBCR and on exchange of information, but it's true that the problem arises when you don't have paragraph 2 of Article 9. What do you do about it? And what we're seeing, at least in the Brazilian case, is that multinationals just, you know, they enter into double taxation, and it's a part of their sunk costs to operate in that jurisdiction. But that's what we're trying to achieve, to make like some changes in order to avoid this as much as possible. But because it's not only a transfer pricing issue, it also impacts at the Brazilian level on other things. They may be missing out on further opportunities on those foreign subsidiaries because they're doing the strict minimum, instead of maybe they have the capacity, the technical expertise, but projects go just elsewhere. And in a country as Brazil that has been suffering from economic problems and so on, it's important for them to produce work for the youngs and so on. So it's true, it's complicated.
Okay, any questions from your side? So then we have to move on.
Yeah, let's move on. This will be the final case. Let's keep it short as well in order to stay or keeping up with the schedule. Basically, the one kind of a legal issue that comes into is on the table quite often in at least in the Finnish transfer pricing audits is the discussion what actually can be subject to a transfer pricing adjustment, whether the tax auditors or tax administration should only adjust the terms and pricing of the transaction, or whether the whole structure of the group business model can be reshaped or even restructured in a way that the transfer pricing adjustment actually deals or is calculated on a totally different type of transaction than what the company has actually carried out. And this is a question we don't need to go into details regarding that this particular case, but I guess this is an interesting discussion how domestic transfer pricing provisions differ in different countries in terms of the limits of the transfer pricing adjustments. And for Finland, basically the dispute or the question is how, where is the limit or the difference between the delineation and the recharacterization of the transactions? And there are quite many cases in courts where these will eventually be clarified. But what about Germany or Slovakia? How stuck are the tax authorities with the actual transaction that the parties have carried out?
Yes, I mean, this is always in practice the case. Tax authorities are very much interested into the truth, what has actually been undertaken. And I guess it's a very important issue that you have already mentioned, Renata, in your first case explanations, so to say, is that we also are making the experience that just having a look into the transfer pricing documentation is sometimes not enough from the viewpoint of tax authorities. So they are going for interviews with people coming from the business side to understand what is going on business-wise. So I can fully underline that, what you were saying, Anari, is that the actual conduct of the business has a much more important role nowadays. Yeah.
Yeah, I can just agree.